Hey, it's Brooke. Welcome to the final discussion episode. I had planned to have a conversation with Richard for this episode, but fate has kept us from connecting. However, it was a really great panel group, and I can't wait for you to hear it. This episode's guest host is Rebecca Lavoie from the podcast Crime Writers On. I have to admit, she's been one of my idols in the podcasting world from the beginning. She's professional, she's smart, she has good insights, and she's funny. I was so thrilled when she agreed to host this episode. And so I'm going to turn things over to her right after the break. I use stamps.com pretty much every day for packages, letters, and sending out swag with my logo stickers on them. Last week, I had to go to the post office to check my P.O. box. And while I was there, I decided to drop off a couple of packages that I had printed postage for right at my desk using stamps.com. The postal worker lady was very nice. But when she saw the Stamps.com logo on my packages, she got curious. She asked me about my digital scale. She asked me about the convenience of printing at home. And now, even my local post office worker is considering using Stamps.com service. I use Stamps.com because it saves me time and money. And the people that I met from Stamps.com were super friendly and helpful. That's a big sell for me. And right now, you too can enjoy Stamps.com service with a special offer that includes a 4-week trial, plus postage and a digital scale without long-term commitments. Go to Stamps.com, click on the microphone at the top of the homepage, and type in Convicted. That's Stamps.com, enter Convicted. Stamps.com. Never go to the post office again.
Thank you very much, Brooke. And I will introduce the rest of the panel. First off, Colin Miller. He's an associate dean and professor at the University of South Carolina School of Law. He's also the blogger behind the Evidence Prof blog and co-host of the Undisclosed podcast. And of course, I like to call him Legal Siri because it seems like he knows everything about everything when it comes to citing case law. Hello, Colin. It is very nice to talk with you.
Hey, Rebecca. How's it going?
It's going pretty well. Also joining us is Rachel Kamins. She's a criminal defense attorney with Offit Kerman. She represented Richard Nicolas and has been featured on the Convicted podcast. Rachel, it is wonderful to talk with you.
It is so wonderful to be here. Thank you.
Finally, joining us is an expert in the field of forensic pathology, Dr. Donald Jason. Now, Dr. Jason, you're based in Winston-Salem, North Carolina. You're affiliated with hospitals. You've been a teacher. You've been a medical examiner. Can you just fill us in a little bit on your career and the work that you've done as a forensic pathologist and medical examiner?
I started my interest in forensic pathology by doing an elective forensic pathology in my 3rd and 4th years of medical school, and include watching autopsies, including going to the law school and testifying in moot court. That's when the law students acted as if they were lawyers, and medical students acted as if they were doctors in turns out it was a medical malpractice case. In any case, I became interested. I wanted to become a medical examiner when I finally got to that point. And for that, it requires you do a pathology postgraduate training, which I did. I also served 2 years in the United States Navy as chief of pathology at several naval hospitals in New England. And I came back to work as a staff medical examiner in New York City for 3.5 years. Then I moved out to Long Island to Suffolk County and was a medical examiner out there for 4.5 years. Then I moved down to Atlantic County, New Jersey. That's where Atlantic City is. And I was in charge of the office in that county for 10 years. And then I went down to North Carolina and joined the faculty of the Wake Forest School of Medicine in the Department of Pathology, and mainly teaching residents in pathology how to do autopsies. We also trained some fellows in forensic pathology there, and I was in charge of that program for a while. So all told, I've been in this field for 43 years.
Wow, that's a long time. And you have not listened to the Convicted podcast. You weren't intimately familiar with this case, but you have read some of the reports, right?
I have never listened to a podcast. I've never listened to the convicted one in particular. The
Right.
only thing I've read about this case was reading Dr. Schutz's testimony.
Right. So we're not going to ask you to weigh in with a medical opinion. I think some of the listener questions were just a little bit more general about how those reports are used. We are going to get to that. I just want to ask Colin, though, because I know, Colin, your work, on the Adnan Syed case, I read your blog. I know some of the other things that you sort of write about and talk about. What is your...
I also went to law school, graduated, and passed the bar in New York.
Oh, and that's a difficult bar, from what I understand.
I studied hard to pass it.
All right, now I feel a little bit overwhelmed intellectually, I'll be honest with all of you. But Colin, I did want to ask you, what has your interest been in the Richard Nicolas case? I know you have written about it, but I'd love to hear your connection to it, and why you find it an interesting case to write about and look at.
Yeah, what I find maybe the most fascinating issue in the Adnan Syed case is the lividity issue, because it seems the lividity in that case is fundamentally inconsistent with the story told by Jay Wilds and the narrative spun by the state. And this is another case involving Cristina Gutierrez, the same defense attorney, where it seems the case turns on lividity. And in fact, as Brooke has noted, the prosecutors in the case said this was a case that turned on lividity evidence.
Now, Rachel, you worked on this case as a defense attorney, correct?
Yes.
And you've continued to maintain some involvement and some contact with the case. Now, you're not currently representing Richard in this case, correct?
I am currently representing him. Once his case went as far as it went through the federal system, he came back to me, and
Got it.
we are now, I'm representing him, and we are now brainstorming our next move.
So how has the podcast and the attention that it's brought to the case affected your work? I mean, is this what you expected? When Brooke picked up the story and started doing this show, has it changed, the way that you look at it, the way that people talk to you about it? I'm just curious to hear a little bit about that.
Well, because there's nothing actually pending in court at this point, and Richard and I are more at the stage of, like I said, figuring out what our next steps are going to be and what specific types of motions or petitions we're going to file next in state court. This podcast has actually been a really good tool for the brainstorming process. It's kind of caused me to go back and review a lot of the evidence that I hadn't looked at for a few years, and, kind of made it more of a daily conversation with Brooke, piling through or pouring through the boxes and mountains and mountains and mountains of files and evidence. It's served as a really good refresher course, and it's given me some interesting talking points and thinking points and discussion topics. So I look at it as really instrumental to whatever next steps wind up being taken.
Now, Dr. Jason, a lot of Brooke's listeners did send in questions about the lividity testimony and autopsy stuff. So I'm hoping I can just ask you a couple of their questions, and as best as you can kind of give your perspective based on your experience. One of the questions that I think is important, not just to this case, but as Colin mentioned to the Adnan Syed case, is that cases sometimes do turn on lividity. And a listener did, point to the fact that Dr. Schutt first said lividity confirmed a victim had been dead for at least 2 hours, but in his later statement, he said lividity is not an accurate indicator for time of death. Can you give an overview of what it is an indicator of? What is it actually useful for in these cases?
It can be useful depending on when it's observed, and the closer it is, the earlier it is observed, the more useful it is. And other factors have to be taken into consideration. For example, the temperature that the body is kept at, and what position the body is kept at for how long, and at what temperature during that period of time. And I haven't seen anything in what I've read of Dr. Schutt's testimony that really addresses that. But in general, what will happen is blood will sink towards the center of the earth, that is downward, relative to the Earth after the circulation stops, and the blood will make that lower portion of the body, whatever the lower portion is, more red relative than the other portions of the body. And with time, the blood will coagulate, or the red cells will break down, and the hemoglobin will spread out and stain the surrounding tissue. At that point, the lividity becomes fixed, that is, will not move. And by fixed, we mean that when pressure is put to that portion of the body that is red, depending on how much pressure is put and for how long. And that is a very subjective thing.
Well, in this case, lividity was not tested at the scene of the crime. It actually was only tested 13 hours later when the autopsy was done. And I just wondered if that's typical.
It's not so much tested as observed. And as far as usefulness for either time of death, it's not useful at all. It's only really useful in a case like this if it's observed and tested as soon as the body is discovered.
Right.
We know the person is dead. So that's sort of like time zero. Then the question is how long the postmortem period was before time zero. And so if you're wondering about what happened 13 hours later, I mean, the body could have been in all kinds of positions in the meantime and all kinds of temperatures. And so an observation of lividity made at the autopsy 13 hours later is only going to be confusing.
Right. And it could reflect, I mean, we did have a question here about transport of the body. 13 hours later, if a body is transported to the morgue in a specific position at a specific temperature, that could change the lividity, correct?
Of course, yes.
Right.
Exactly. That's what I'm saying.
Now, Dr. Jason, I have a question about something that I don't know if you have ever seen in any of the cases that you've done when you've looked at victims in autopsies and written reports. There's a question here about bullet trajectory through, and this is again specific to this particular case, so I know that you won't know the specific answer, but the question was, Brooke keeps theorizing that because the bullet went straight through the shooter, was at the same level, could Richard, a tall man, have positioned himself in a way that the bullet went straight from inside the car? Now, the question I want to ask you is, if you've ever had to write a report to help investigators determine the recreation of a crime based on what you reported in terms of bullet trajectory through a body. What's your experience with that?
Yes. Reconstructing how the body was relative to the gun is one of the things we regularly do once we know all of the facts. Because the gunpowder comes out of the barrel of the gun in a cone once the gun is shot. And it can be blocked by anything that's in the way. So maybe it may not be a perfect cone on the body if something is blocking it. I have no idea what in this particular case.
Right.
Could it be the arm of the victim? I don't know.
Right.
Could it be something else? I don't know. But to say that it's going straight through the head, but what position the head is depends on what position it is, whether it's flexed or extended, or turned to one side or turned to the other side. When you say straight, usually you're referring to the body, not the head, because the head can turn around in all kinds of positions. As you know, you can move your head around on your neck, so that all I can say is bullets go straight, and did in this case from my understanding of how the wound was. And then the question appears that a portion of the bullet was left in the back of the head, but that's only the jacket. Where the core of the bullet went is apparently unknown. It would be nice to know if they ever found it, or even ever looked for it. The core of the bullet continued out the exit, and no indication in what I've seen was whether it's ever found or looked for. That would be very important to know.
Well, it's my impression that the bullet went basically through her left eye and lodged in the back of her head. And it was a direct route. It didn't go up or down, like there was no slant to the bullet.
The way I saw it was in her cheek, 1 inch to the left of the midline is what was said.
Right below her eye.
Below her eyes. And of course the face is not flat, front. It's sort of sloping off to the side at that point. So that has to be taken into consideration too. But if you measure from the top of the head, apparently it's the same distance from the top of the head in the entrance and the partial exit. So yes, that would be in the anatomical position. And the anatomical position is a person standing straight up, looking straight ahead. And there's other qualifications for the rest of the body too. But as far as the head is concerned, it would be the person with the head facing straight forward.
Mm-hmm.
And if the measurements were taken correctly, and the pictures would help along those lines
Mm-hmm.
to see if measurements were taken correctly. But from what I can read in the testimony of Dr. Shute, it appears that if the head is considered to be looking straight forward, yes, it's straight front to back, but of course, and the gun would sight along that line. That's all I can say about that.
Well, I guess my question is, if the gun does go from straight front to back, is it likely that the gun was at the same level as the cheek or the entry point?
Well, I don't know what you mean at the same level. If you look down the barrel of the gun, it would sight the entry. Whether it's at the same level relative to what?
Relative to the place that it went in.
Like height-wise?
Yeah, so I'm saying, like, if a 6-foot man was next to a 2-year-old little girl, obviously his arm would have been
Are they both standing?
They were
straight up?
sitting.
Well, then it depends on how the victim's head was situated.
I have one more forensics question for you, Dr. Jason. A question about gunshot residue. This is Emma who submitted this question. She cites some facts from the case that she learned from the podcast. She says, I don't understand how the gunshot residue didn't exonerate him. There was no murder weapon found, and he didn't have time to dispose of it and only had limited GSR particles on his hands. She asked the question, what is the truth about gunshot residue? Are numbers important? So I'm curious to know what your experience with that is.
Well, gunshot residue depends on the gun, how much residue will be left when a particular gun is fired. And then, say on the hand, what portion of the hand? Is it the back of the hand? It will tell you where the gunpowder was deposited. And gunshot residue on the hand of someone may indicate that he was handling the gun that had been fired, or possibly firing the gun, but maybe not.
So it's not the end-all, be-all. If there's like a speck of gunshot residue, you probably shouldn't be convicted based on that alone, is what I'm hearing you say. Right. Now, I do want to know, I'm just curious, you've had so many positions as medical examiner, as pathologist, and you've probably testified in a lot of trials. Have you ever been in a position where you've done your analysis, done your autopsy, written your report, testified in a trial, and then you found that, the report that you wrote, which was based on the science that you did, perhaps later, maybe when you were finished testifying or in any other circumstance, wasn't being interpreted accurately when the case was being prosecuted or defended? Have you ever found yourself in that situation where you're like, wait, that's not what I wrote down. That's not what it meant?
No, not really. The only time I will change my opinions would be based on new evidence.
Mm-hmm.
Now, of course, I have testified where there have been experts testifying on the other side. Most of my testimony has been for the prosecution.
Mm-hmm.
I have testified for the defense on occasions. And have I changed my mind because of what the expert on the other side says? That's his opinion? No.
Right.
Not unless there's new evidence that comes in.
I have a question. Have you ever been written a thank you letter for your testimony in a trial?
No, I have been paid for my time.
But no thank you.
Well, occasionally, the attorney who has hired me said thank you. Your testimony helped. I'm lucky if they tell me what the result was.
That's right. It's a gig, right? You're coming in to give your opinion and tell the truth, and then you're moving on to the next case.
Tell the truth. That's what I'm there. I'm the only one there who's sworn to tell the truth, not the attorneys.
Well, Dr. Jason, thank you so much for joining us and lending us your many, many years of expertise. These are questions that we certainly couldn't have answered without you here, so we really appreciate it.
Well, you're quite welcome. It's been a pleasure. Thank you.
Last week at Podcast Movement, I was fortunate enough to meet the creator of a new podcast called Deliberations. I absolutely love it because it addresses the legal issues that my podcasts also address, but from a completely different angle. When we hear about wrongful convictions or unfair trials, we have this nagging question of what happened in the jury room in our minds. That's the question that Deliberations helps us to answer because it takes us into a mock jury room. It starts with the controversial fictitious murder trial that's played for a mock jury. Then we hear those jury members react, debate, and argue their opposing opinions on the evidence. Season 1 explores the way a defendant's alternative sexual lifestyle brings out bias and influences the opinion of the defendant's moral character. This podcast puts you directly inside a deliberation room, and it helps us to gain better understanding of the process by which guilt and innocence are decided. Visit iTunes, Google Play, Stitcher, or your favorite podcast app and search for Deliberations. Again, that's Deliberations. What do you think? Is our jury system flawed?
Now, Colin, there have been a lot of listener questions about the lividity in this case and crossover with the Adnan Syed case, and I know that's something that you've written about. So one question, this is from a listener, Lori. She says, my question would be something along the lines of how can the lividity be used to help Richard's case? I understand it undermines the state's theory, but doesn't feel like it's a game changer. And then lividity was also very important in this case, was also important in the Adnan Syed case in the fact that it was inappropriately applied. Does the fact that Cristina Gutierrez was involved in both cases help Richard or Adnan, or one more than the other, I think is the gist of her question. So I think she's really asking about the crossover. And I know that you've written about this. I'm hoping you can fill us in.
Yeah, so a couple takes on that. First, in terms of how it helps Richard, the court, at least to the effect they've ruled to this point, has said it doesn't, because while it doesn't support the prosecution case, it also doesn't support the defense case. My counter argument would be, I think it shows the lividity analysis was done incorrectly here, and I think that's the point the doctor was making. And so I think in this case, it certainly has the capacity to help Richard. In terms of Gutierrez handling it in both cases, I don't really see lividity being an issue at this point in the Adnan Syed case, certainly if he's given his new trial on the grounds that have already been granted. But yeah, I mean, I think this certainly shows a pattern where Cristina Gutierrez was handling multiple cases and failed to grasp lividity in either. And I think that the evidence shows it really was a central issue in both cases, and attacking it effectively could have at least created reasonable doubt in those cases.
Now, Rachel, there's a question here from Tara. This is about court reporters and stuttering. Tara actually is a court reporter. And she says, I file many appeal transcripts for cases that are being appealed. I'm super curious if the Court of Appeals in Maryland had a transcript that was verbatim to show Richard's speech issues, or if it was cleaned up or if it had cleaned up all of the false starts. I'm paraphrasing her question a little bit because it's long. She said, I'm curious how the Court of Appeals read into his testimony. This question is also self-serving because I think about myself and I wonder how I would handle that. So can you just talk a little bit about how that speech pattern stuff was or wasn't integrated into the official court record?
Yeah, I really love that question. I mean, that's a very insightful question. And the unexciting answer to that is that the answer is it was cleaned up. It wasn't completely cleaned up. If it had been represented the way he speaks, the transcript would not be 3,000 pages long. It would be 100,000 pages long. So certainly, as a practical matter, there had to be some cleaning up of it. And the reason it was relatively, I guess, easy to clean up or even easy to transcribe was because Richard's stutter is not, I don't know the right terminology for speech impediments, but his stutter is not getting caught on the first syllable or really any syllable within the word. It's more a halting hesitation kind of stutter. There may be long silences between words or particularly at the beginning of a sentence. So unlike a stutter, which would be like repeating the T sound, in tennis, like t, where to really get the full flavor of the stutter, the court reporter would actually have to type the letter T 10 or 20 times. This is more like there's just these enormous spaces between sounds. So you can't see those spaces. There's no, ellipses or blank spots in the transcription. It pretty much reads as though he does not have any speech impediment. And to the extent that occasionally he may stutter the first letter or sound of a word, it might just be represented as, he did that once or twice at the beginning of the sentence, but by no means is the court reporter literally transcribing the sounds that are coming out of his mouth. It is definitely cleaned up. So a court looking at the transcript would have absolutely no sense of the extent to which he struggled to get his words out.
Now, we actually have a follow-up question here. Sarah had a really interesting two-part question, and maybe Rachel, you could tackle it, and Colin, then you can weigh in if you have heard of anything like this in any of the gajillions of cases I know that you have memorized in your giant brain. What Sarah wants to know is if Richard had a diagnosed disability. She says, I am focusing on his speech. If I recall, he had a birth injury that led to his stuttering later in life. Does this qualify him as being disabled? And then she basically goes on to ask if there are accommodations ever made for people with disabilities like this at trial. Again, I'm paraphrasing her question. So, Rachel, is that a diagnosed disability that Richard has?
Well, do I understand your question to be asking, was he diagnosed with a disability? And if so, is that a recognized disability such that he would be entitled to accommodation? So a speech impediment such that he had, regardless of what the origin was of the speech impediment, is not a recognized disability that would entitle him to whatever kind of accommodation. I guess I don't even know what it would look like, but no. The answer is no. And then the first part of that question is, did he have a diagnosis? And I think that his diagnosis, to the extent you want to even call it a diagnosis, is that he had a really bad stutter. But, was it anything more than that? Was he diagnosed with, particular neurological phenomenon that caused him to stutter? Not to my knowledge, ever.
Right.
Is that right, Brooke? I mean, Brooke will probably does that sound accurate?
That sounds accurate. But he was born in the 60s, and I think that if he were born today, that maybe things would have turned out differently.
Yeah, should he have been diagnosed as having, a disorder or disability? Absolutely, he should have. Was he? No.
Colin, did you have thoughts?
Yeah, I was just agreeing with Rachel that a speech impediment or a stutter is not something that's been recognized as a disability under, say, the ADA. And certain witnesses can get accommodations like a service animal, but I've never seen anything like that with a person having a stutter as a witness.
Right. And even though the record of a trial is very often a transcription, so there isn't, there isn't like a special box where a note can be made, to whomever in the future reads this transcript. One thing to keep in mind is that this witness had a speech impediment. There's no place for that in the official record, right?
There's not. And occasionally a court reporter will make a note of something like witness just sneezed or something like that. I never really understood why, or, witness giggles put in parentheses. Sometimes, I see that, I think, well, why do we need to know that? But I guess they're just being really, really accurate. And
Right.
that's, I guess that's better than not being accurate. But
Right.
there is not, I've never seen, and I don't think there is any really opportunity to put in the transcript that the witness, has a particular manner of communicating that's different from the norm.
Right. Now, Brooke, I've got a question for you. Trent from Facebook had a comment that I would love to hear your take on, because I know that you've spent a lot of time talking to Richard. Trent, the gist of his comment is that this is a very sophisticated crime, or would be, and it's too sophisticated for Richard. He says Richard didn't put much thought into planning things in his life. He bought life insurance through a baby food company that advertised on TV. A person who thinks in plans would have looked at half a dozen plans from a few different companies. I don't think Richard has a trade. He was a guy who worked hard with no plan, no goals. Are we supposed to believe that a man living simply is going to orchestrate an elaborate murder? Now, he kind of goes on here, but you get the gist. What do you think about Richard? Do you think he's more sophisticated, perhaps, than Trent is giving him credit for being?
I think Richard is intelligent, but because of the way that he speaks, he's sometimes perceived as not as intelligent as he is. I think at the time in the 90s when this happened, he was living a young man's lifestyle and making a young man's choices, and those weren't so responsible. But I think Richard is not necessarily a sophisticated person, but he's a smart person and he's capable of making plans.
Rachel, this is a question from Liz on Facebook, and Kenny on Twitter basically asked the same question, which is, did Richard's family and or anyone ever hire an investigator to determine a little bit more about the case, who the actual shooter was? Were there any other, at any point, alternative suspects identified by somebody working for the defense?
The defense did have an investigator, at least one investigator, and there was never any alternative suspect identified or even, suspected. I think the investigator basically came up empty. What I recall, and this is going back many years ago, when I was trying to figure out what I needed an investigator to do, and I had to determine what an investigator had done thus far in the case, my recollection was that the investigator did go to the movie theater, tried to procure tapes, like surveillance tapes from the movie theater, from the gas station, and also tried to or did, in fact, interview various people with whom Richard had interacted that night. But in terms of actually being put out there on the street to try to find the shooter, I don't think so.
Okay. Now, Colin, this is something I know you've written about, so I'm going to throw this one your way. There were some questions from listeners who did not want their names to be included, I suppose. The first question is, who is the unimpeachable source? Now, you wrote a blog where you mentioned the unimpeachable source. So I don't know who the unimpeachable source is. What are your thoughts just about the use of the unimpeachable source and who that might be? And what does that even mean when that's included in something like this?
Yeah, I really do wish that we had more information. And it's something Rachel and I have been talking about in terms of the appeal. It might be the private investigator who is working for the defense. It might have been an attorney at the firm. It might be a paralegal. I don't know. Clearly, it's someone who's privy to conversations that the attorneys had about the lividity evidence and was able to ascertain that they didn't understand it and could communicate that to the prosecution. But that's really maybe the biggest unanswered question I have in the case.
So here's another question that I think you are equipped to answer. How can something be a factual finding if it's not true? And this is the idea that something can be a finding of fact as long as it's reasonable, right? For a jury to interpret it as fact. Isn't that what that is?
Right, yeah, and it's something where, exactly, when we are, as attorneys, appealing a case, you have certain factual findings that are made either from a special jury verdict, or if you have an appeal, you might have a lower appellate court judge making findings of fact. And exactly, the point is the appellate court looks at it and gives every deference they can give to that lower court ruling. And you might look at it and say, well, this finding of fact really doesn't hold water. In fact, there's a much stronger conclusion that could have been made on the other side. But really, appellate courts are loath to come in after the fact and look at a cold record and say, we're going to disturb these findings of fact.
Right. Now, this is like, I think about something like the Adnan Syed case, and previous appeals courts sort of looked at the cell phone expert said this, and even if it might not be accurate, it was reasonable for the jury to think that that was the case, right? And it wasn't until that other piece of information came out, like the cover sheet, that it no longer was reasonable for that to be a finding of fact. That's kind of an example of that, right?
Right, yeah. Or when a person is appealing a conviction, they often say, we're looking at the facts in the light most favorable to the prosecution, meaning it might not be true, but we're going to go ahead and assume it's true for purposes of this appeal.
Right, right. So, Rachel, one of the things that comes out in the podcast, and I'm reading all the summaries of this case I read today, and a lot of media sources and other sources is, and I couldn't find a reference to it, so I guess this is true, this question that came in, that there's no murder weapon. Doesn't seem to be emphasized in the investigation or the trials, but isn't it important when there's no weapon that you can compare evidence to when you're, prosecuting and or defending a case?
You would think, wouldn't you think, that would be a really compelling piece of, missing evidence?
If I were a defendant, I would certainly think that for sure, yeah.
You would really count on that, hope that there was no murder weapon. So there was no murder weapon found. The fact that there was no weapon found, and I think that I saw a comment on some form of social media where somebody said, how on earth in that incredibly short time interval could he have even disposed of it? And we know that the police literally turned the earth with earth movers and bulldozers and stuff. That whole area within, I think, a square mile of the crime scene, they scoured. And dogs, they looked like crazy for the murder weapon, and it's never been found. And of course, not having the murder weapon means that you cannot, link it definitively to the defendant via fingerprints or, other DNA evidence. You cannot link it definitively to the bullet that was found in the victim. So it was emphasized at trial that there was no weapon, and the inferences to be drawn from the absence of a weapon, which is, how could he have disposed of it? And certainly the fact that he didn't have one made it much less likely that he had been the shooter. But I think one of the ways that the state compensated for the absence of a murder weapon was to highlight for the jury that Richard was a gun owner and that Richard had a hobby of, target shooting. And they were able to parade in front of the jury the weapons. I think there were 2 weapons that were found in his home and a whole bunch of boxes of ammunition. And they not only brought in every piece of ammunition and every gun that he either had in his apartment or had ever owned, and every corresponding invoice or bill of sale or transfer slip for guns that he had, bought, sold, traded, etc. It was obscene, really, what they did. And I think that they did that to kind of obscure the fact that the actual murder weapon wasn't there. But look at all these other weapons. And yeah, none of these other weapons were the murder weapon, but who cares? Because he was, kind of this gun-toting lunatic. So I think the state's attorney was acutely aware that they had a vital piece of evidence that was not available, and they decided to, play kind of fast and loose with what they did have to kind of create a false impression.
Right. Colin, what's your take on that? This idea that a gun owner, somebody who has guns in their life, which I think is not uncommon in this country in particular, making that tie between this person owns guns, therefore they're more likely to have committed this crime. Do you see wrongful convictions or suspect convictions where that is a thread that comes up? I mean, is that something that is a common theme, or is that uncommon?
Yeah, this is something that comes up a lot under evidence law. We have a prohibition on what's known as propensity character evidence. So you can't present evidence once a robber, always a robber, or that a person has violent tendencies and therefore likely committed this crime. But there's all sorts of exceptions that have been read into this character evidence prohibition, and things such as, well, this person owned a lot of guns and therefore it's likelier that they could have committed this crime because they had the means to commit it or they enjoyed using guns. A lot of people would say that's propensity character evidence. It can taint the jury. It shouldn't come in. But definitely the trend over the last few decades among courts is to allow this type of character evidence in. And it does create this real risk that we're convicting not based on the evidence of this crime, but based upon what the jury perceives about the type of person this is.
Yeah, it's like the O.J. Simpson thing, right? Like, this is somebody who wasn't convicted of a previous crime, but everybody associates with a previous crime. And here he is in this new crime of this, sports memorabilia robbery. And it results in a different outcome than would happen for just about anybody else who was on trial for a similar crime, right? It's like that prejudicial stuff that's kind of out there.
And what the state was able to do, and often does, is they pretend that the reason that they're bringing this evidence in is to show the jury that this is a man who had access to guns and who was familiar with their operation. And that is a permissible basis upon which to admit the evidence. But the reality is that they're bringing it in to poison the well and make him seem, like I said, like a gun crazy guy, right, who, if you have guns and like to shoot guns, you probably, are more likely to have, I don't know how they reach this, but more likely to have shot your daughter. So
right,
they can basically, as Colin said, the tendency is to let the evidence in, and that's because the state can offer up, a plausible reason, a plausible, admissible, acceptable reason for the evidence. But we all know that that's not what they were doing.
Right, because who else, has guns and knows how to use them are the cops who arrest people and investigate these cases. And, I that's one of the things that I always thought was really interesting. And, as Colin knows, and as listeners of mine know, I'm a big Law and Order fan. We have a whole podcast about it. And that's one of the things that's like a Jack McCoy moment where he'd be like, you know who else knows about guns? But of course that never happens in real life, right? That only happens in our imaginations of how these trials should go. One other crossover, Baltimore really is at this, geographically, there's a lot of issues around Baltimore in terms of crime and a lot of political issues and issues with, corruption and still unfolding new news about Baltimore. But it also happens to be a point where there's a lot of crossover in, real life and pop culture around legal cases. And there are characters and police officers and prosecutors who come up over and over and over again in sort of multiple crime cases, both real and fictional. If you are any fan of David Simon and have ever watched The Wire, a lot of those cops and prosecutors were based on real people from his research for Homicide: Life on the Streets. One of the things that does come up in this case is prosecutor Sharon May, who is also featured in the Netflix series The Keepers. She's somewhat of a controversial figure in that case. And a lot of people wrote to Brooke asking her about Sharon May's ethics, Sharon May's history. And I'm not going to ask you to speak to those specific things, Rachel, but I do know Brooke tells me you have some experience up against Sharon May in the courtroom. Is that true?
Well, I don't have experience against Sharon May in the courtroom because so she was a prosecutor. She is currently a defense attorney. And by the time she became a defense attorney, so I had been a prosecutor when she was a prosecutor. And by the time she became a defense attorney, I also had gone over to the dark side. But
No, it's the light side.
I trust me. I know fully well what side it is. I get that a lot. But interestingly, and this is probably why I should abstain from commenting, I have a post-conviction right now in which I'm post-convicting Sharon May, and we have our hearing in October. And I can tell you that one defense attorney post-convicting another defense attorney, it's super contentious.
Right.
And yeah, I don't know how that's going to go because I haven't seen her since this podcast. But no, I've never been in the courtroom with her, but I have seen her back in her prosecutor days, doing her prosecutor thing. And I can't say that I have anything good to say about her.
Well, I don't want to put you in a position that puts you in an awkward place. But I guess my question is, she's portrayed a certain way. I think especially in The Keepers, like she's definitely framed as a character in that documentary. And as somebody who watches a lot of true crime media, I have a little bit of like a BS meter when I watch the portrayals of, different prosecutors and cops and characters and defense attorneys. And I didn't know much about her before watching that show, but I guess what I'm getting from you is that putting that like little bit of light on her may be warranted because she actually is she is a character of some kind.
Can I make a Sharon May comment?
It's your podcast, Brooke. You can say whatever you want.
I know, but I made you the boss today. So I've watched Sharon May's debut on The Keeper like 27 times. And before that, my only contact with her was one email, and it was very short, and it felt very cold. And I really didn't want to like her. And then when I saw her on The Keepers, I felt like she was charismatic. She seemed very straightforward. She seemed like a jury would perceive her as genuine. And so I think she was probably a very effective prosecutor. I wanted to hate her, but I couldn't just because of the way she presented herself. I think that she was probably very good at her job.
She was very good at her job.
Yeah. And a lot of people in the courtroom, who are very good in the courtroom, that charisma is really important. I mean, I have exposure to a lot of cases in my state, just from the true crime books that I've written with my husband. And on both sides, people who are very, very good as both prosecutors and defense attorneys, charisma really is the key component. And really, really good attorneys, your impression should be, yeah, I really want to go grab a beer with this person after the trial and, pick their brain a little bit. That's kind of what makes for someone who's good in the courtroom, right?
I think so, for sure. I think it makes all the difference. I mean, a lot of times trials are insanely boring. The things that are depicted on television are like the interesting parts, but jurors have to sit through hours and hours and hours and hours of incredibly boring shit. And so if you have charismatic attorneys, the more likely they're going to keep the jurors' attention, and the more the jurors pay attention, to what you're saying, the more likely they're going to side with you. So I think that's incredibly important. And she definitely had that. Yeah, sorry.
Yeah. I would love to, yeah, it's okay. I've always kind of thought I would love to see what Colin would be like in the courtroom. I know he loves being a teacher, but I don't know, Colin, I think you have a unique way of sort of explaining how things should be. I think you'd be good at it. I'm just going to throw it out there.
Your next career.
Yeah, Colin, he's just like, no, I can hear it. Now, here's a question from a familiar character. This is from someone named Brooke from the Convicted podcast. And Brooke wants to know, Brooke, do you want to just ask this question or should I read it for you?
Yeah, Rachel was the original handler of Richard's habeas petition. And she is actually the one who contacted Dr. Shute, the medical examiner. And I just wondered if she could tell more about that experience, like what made her contact him and what his response was.
Okay. Well, I mean, this is going to sound so ridiculous, but when I first got Richard's case, I had never even heard the term lividity. I mean, that's just, I'm being candid. It just doesn't come, I mean, in my cases, it just didn't come up as an issue. And so I literally went to Barnes & Noble and bought Forensics for Dummies. And I read...
Wait, one of those like For Dummies books as a forensics one?
Neon yellow For Dummies books.
Like Windows for Dummies or like, oh my gosh, I didn't realize I have to go buy that myself. That would come in very handy in my line of work.
It probably would. And I learned so much. And this was this was in like 2008, I guess. And I mean, yes, there was an internet, but not like there is today where you would never go to a bookstore and buy a book on something. You would just research it online. But we weren't really there yet, or at least I wasn't. So nowadays I would just Google, a million articles or learned treatises on the subject. But I actually bought that book because I figured, well, I need to really start with the basics. And I studied up on lividity, and that led me to read a few other journal articles and stuff. And the more I was reading, the more I thought his testimony just doesn't seem, it not only didn't seem correct, it seemed incomplete. And I think the reason it struck me as incomplete was because all the questions that you would expect to be asked on a cross-examination to try to tear down what he said on direct concerning time of death based on lividity weren't asked. They just were not asked. And it struck me, relatively quickly after educating myself on lividity that there's just this gaping hole in Richard's trial. And standing in the shoes of his defense attorneys, I came up with like 20 questions that I really wanted to ask Dr. Schutz. So really on a whim, I just did a Google search and found him at the medical examiner's office in some tiny little town in upstate New York. And I called him, and I'm pretty sure the first time I called him, he answered the phone and he remembered the case really well. And he was extremely gracious to me and willing to talk to me. And that led to a couple conversations and him agreeing to answer a series of questions that I posed to him, first in the phone call and then followed up with a letter. And then he wrote me, a 2-page letter. And I was able to ask all the questions that I felt should have been asked at his trial. And when he answered those questions for me verbally and then in writing, I realized, well, gosh, if he had been asked those questions at trial, I don't think Richard would have gotten convicted. And that, of course, led to the allegation of ineffective assistance of trial counsel in not handling the lividity issue well by not procuring their own expert and also not having the right, the ammunition to cross-examine him, Dr. Schutz.
So are those I have to just ask, because I've always wondered this, with people who take on cases like this and start doing this work and have to learn and then have these moments. And I know it happens in journalism when you're doing an investigation or even just researching for a book. And you have those, I call them oh shit moments, where you turn a page and you see something and you're like, oh shit. How many of those did you have when you were learning all of these things and ramping up and talking to people and realizing there were all these holes? I mean, can you even quantify how many of them you had, or was it just too many to count?
Richard's case was one nonstop, and continues to be one nonstop oh shit. I could never quantify how many oh shit moments there were in this case, because I could have an entire, I've been doing defense work for half my career, so 14, 15 years, and Richard's case has more oh shit moments than all my cases combined.
Right.
And lividity is a big part of that, but there's so much more.
Yeah. Now, in terms of, we were talking about oh shit moments before that, we were also talking about Baltimore sort of being like this, confluence of all of these different stories around, famous cases and infamous cases and police misconduct. And, it's sort of like this geographic nexus of all these things. And Kim from Facebook asked a related question to that. She says, recently the Detroit Police Department announced they would be looking into all the cases of certain officers that resulted in wrongful convictions. And then she asked some specific questions about Detective Massey, Sharon May. But her larger question here is, given everything that's been going down in Baltimore, do you think Baltimore would be willing to do the same thing? Or is perhaps Baltimore itself a Pandora's box situation, given how we've seen the state, in particular in Maryland, fight the way they're fighting the Adnan Syed case with, volunteer prosecutor in that case and so forth. Colin, do you think there's hope that Maryland or Baltimore in particular would look at these cops and look at these investigators and maybe reopen some of these cases like Detroit is doing?
No, and this is something where they've
sad.
it's really been in the opposite direction. Daryl Massey, going back to your point about these intersections with pop culture, he's the basis for the Bunk character in The Wire, and he's infamous in Baltimore for this overtime scandal where he was, in essence, getting tens of thousands of dollars in overtime pay, and they actually did a sting operation with him and found, when he charged certain hours for working, he was at Food Line. And a big thing that happened and is being litigated now in Maryland is that they have said that these personnel records, such as showing his overtime abuse, is not covered by the Maryland Public Information Act. And that's led to a lot of defendants trying to have their convictions thrown out for cases that Massey worked, being precluded from getting that information that they could then use to have their appeals granted. And so, yeah, quite contrary to what's happening in Detroit, it seems that they're closing ranks in Maryland and Baltimore, and it'll be exceedingly difficult for anyone to even get the information they need to have these appeals.
Well, that's really uplifting, Colin. Very.
Yeah. And let me just chime in that somebody asked a question, I think, on Facebook, and I just want to add to what Colin just said. We have in Baltimore a conviction integrity unit, and so many of my clients are under the impression that if they just contact the conviction integrity unit and present these outrageous things that happened during the course of their trial, they're going to get a fair, fresh set of eyes on their case. And I have to always be the buzzkill and tell them that the conviction integrity unit is a division of the state's attorney's office. It's not, an impartial, unrelated group of people looking at these convictions. It's just a bunch of prosecutors.
Right.
And that's extremely disheartening.
Well, this is something that I know Colin has, written about and talked about on the Undisclosed podcast, specifically, not just this integrity unit, but even when it comes to, labs, even when it comes to, the organizations that are presenting the quote unquote, unbiased evidence that's going to be used in trials. All of those, operations are state-run, state-related, state-contracted, and unless you have the resources as a defendant to get your own, attorney to look at the integrity of your conviction or do their own laboratory tests, you're really at the mercy of operations that are just by the way that they're built on the state side. It's really something. It's like, what do you have to do to get a fair look? It seems really overwhelming, when you point out something like that. And speaking of, one final question I have, Rachel. I mean, I think, kind of where the podcast ended, it certainly leaves me with the question. And also not just me, I mean, Rob answered this question, Brooke answered this question on Facebook, listener Brooke, does Richard have any options legally at this point? Is there any hope for the case? Are there any challenges left to make? How can listeners help out? Rachel, can you just address that, where we are, where this could go, and how listeners, if they're interested in doing more, might be able to do so?
Well, starting with the last thing that you said, the way that listeners can help, if they so choose to help in this way, is to contribute to his legal defense fund. And I want to clarify that his legal defense fund is solely for retaining expert witnesses. So what he needs, if he stands any chance of being able to take his case back to court at some point, is to retain experts potentially dealing with the gunshot residue evidence, potentially dealing with the lividity evidence, and perhaps other forensic issues involved in the case. These experts are monstrously expensive, and really nothing can happen. I mean, his case has been up and down and up and down and up and down, as the podcast recounts, so many times through state and federal court. It needs to be packaged in such a way that, something new is being presented, and that's going to take money. And I'm going to handle the case pro bono, as I always have, but I haven't yet met an expert witness who's willing to do the same. So that would be the number one way that people can help. And of course, spreading the word and just, kind of being aware of these injustices that take place. But on a very practical level, he needs money for those things. And, I have no intentions of ever giving up on this case. This is the case of a lifetime, in the sense that there never has been, nor will there ever be, more of an injustice that I can even conceive of in my mind. And the system allows for, kind of perpetual litigation. It's not ideal to keep going back to court, and each time you try to go back to court, you're sort of looked at with less favor. But the podcast, the federal habeas corpus, and the process of the habeas corpus, and all the evidence that was uncovered during the course of that, and the podcast have put into perspective some new ideas for trying to reopen Richard's post-conviction, or trying to do at some point a petition for actual innocence. So that was a really long-winded way of saying there are legal remedies available to him, and I intend to, pursue whatever ones are most appropriate for him. But by no means is this an easy battle. He's lost at every turn, and so the cards are very, very much stacked against him.
Episode 11, the final episode, will be out on September 11th. A special thank you to Rebecca for being our guest host, the panel guests, Rachel, Colin, and Dr. Jason. And of course, check out their podcasts, Crime Writers On and Undisclosed. The transcripts were made by Christina, and the music was created by Blake Maples. You can see and hear his work at blakemaples.com. I'll see you next week. Thank you so much for listening.